All right, everyone. Our next topic is Voir Dire. And our presenter is David Frink. David received his JD and a master's degree from the Vermont Law School. He's been practicing criminal law since 1993. David is board certified in criminal law. David, as some of you may know, is a past associate director of TCDLA and a past president of the Austin Criminal Defense Lawyers Association. In 2008, he received the ACDLA Ambassador Award. Please welcome, for our Voir Dire presentation, David Frink.
Well, I have the distinct honor of presenting on Voir Dire, which is, I think, one of the funnest parts of the trial and one of the most difficult. In my opinion, while it's a lot of fun to do Voir Dire, it does take a lot of work and preparation. What I'm going to talk about today, in terms of these areas, is to get you also to think about Voir Dire, not so much as jury selection, which it's not, but to think about it in terms of juror elimination, which it is. I'm going to tell everybody who my witnesses are and who the state's witnesses are, because I want to know if anybody knows them. I'm going to start with Mr. Mailer, and I might ask him to please stand up, and I might put my arm around him and say hello to everybody.
How you doing?
Jury's gotten to hear his voice, they've gotten to see him, they know that I like him. He's my client. I'm going to protect him, I'm going to defend him. If there's a breath test officer or breath test technical supervisor, you want to bring that out too. I want to know if they're related to a prosecutor or anyone in city, county, or state government. So I'm going to ask them, do you have any relatives or friends, close personal associates who work for the police department or who are police officers? And now I'm going to get to my first strike for cause. And this is one that everybody ought to use because it's simple and it gets you a lot of good information. Start out by saying some people admire and respect police officers so much that they believe a police officer would never lie in court. And you'll see a couple of hands go up. Who agrees with that statement? Those are folks who are subject to a strike for cause. Now, it needs to be unequivocal. You need to nail it down. But if they are committed to saying, I agree with that statement, police officers would never lie in court, they're gone. In Austin, we sometimes get police officers from APD or Travis County Sheriffs who come in their uniforms, and they sit right there in the front row or wherever they are in the veneer, getting ready to be struck. Ask them if they know the officer. Officer Mabe, do you know your fellow officer, Officer Johnson? He'll say, yeah, of course I do. Is he an honest fella? Sure he is. He'd never come to court and lie willfully in a court, would he? At a trial on a DWI? No, of course not. Thank you. Now, you may not get someone to tell you, I think they won't lie in court, but you may have some folks who will tell you they're not sure about the reliability of police testimony in general, and they would need to hear from this particular officer. Fine. You want to ask them, in general, how reliable do you feel that police officer testimony is and why? Ask them what motivates police officers from making DWI arrests. And here again, you'll get a spectrum of answers from, I think they're just making their quota. They want to arrest everyone they can so that they can just fill the jails with DWI drivers. Or, no, police officers do really good work. It's hard work, it's dangerous work. They wouldn't do that. They're just arresting the people who are really guilty. That's good information to know. You may want to find other jurors who agree. And you may ask them to contrast the testimony of a police officer with the testimony of any other witness, say a civilian witness. And you'll hear everything from a police officer is more qualified and trained so that they can give better observations on a DWI, they know what to look for, to no, they're biased, they have prejudices, they have quotas. Similarly, ask about a neutral witness who happens to be there, a civilian witness, a passenger, somebody who just came out to watch. Find out who those witnesses are, be prepared for it, and bring it up during voir dire. I like asking these questions, and these are building questions. Does anyone know someone hurt by a drunk driver? Does anyone not drink alcohol? Now, these people may have all kinds of reasons for not drinking. Health reasons, religious reasons, maybe they had trouble with alcohol in the past and they've just stopped. But you want to know that, and you want to know what their reasons are. These aren't necessarily bad jurors. This next question, much more important. Is there anyone that does not keep alcohol in their home? This is different from the person who doesn't drink alcohol. This person does not approve of alcohol. That if they don't keep alcohol in their home, they're going to be really tough on your defendant. And lastly, how often do you drink alcohol? You may want to distinguish between the social drinker and the drinker who drinks a couple every day. because those people are going to be very different. I ask if anyone knows anyone else who's been arrested for DWI. Here again, you're going to get a lot of valuable information from, I know somebody, and it did him a world of good. I think DWI is terrible, and that arrest really, really changed that person. 2, no. I think it was terrible, awful. It was a big mistake. This person wasn't intoxicated. He got railroaded by the prosecutor. He didn't have a good defense lawyer. He pled because he wasn't able to afford a trial. I think we've all seen the billboards that say, drink, drive, go to jail. And a lot of people think that is the law. That is not the law, and you need to educate your panel about that. And if you could change DWI law, what would you do to make it different? You might get some people who say, I think the legal limit is too high, it should be lower. I don't think people should be allowed to refuse the breath test or a blood test. You'll find all kinds of answers like that, and no one question or statement here is going to give you the answer to every juror. You might find a juror who is sitting silently throughout most of your voir dire, and then suddenly toward the middle or the end they pop up and they say, yeah, now that you asked that question again, I got something to tell you about that. You want to find out what organizations they belong to and who's a member of MAD, who's given money to MAD. What other anti-alcohol groups do you belong to? Are there any members of AA? Members of AA, I think generally are going to be opposed to alcohol and opposed to DWI offenses. They may hurt your client. Has anyone donated money or spent time with an anti-alcohol group? Are there any members of Crime Stoppers? Find out who these people are. And here's a great one. In Travis County, we have a lot of people who testify at the legislature. We have people who feel that the laws are just plain wrong. Great question. Is there anyone who is a member of a group or organization that has as its goal or purpose, or as any part of its agenda, changing the laws of our criminal justice system? If you get some hands up, you need to inquire what those changes ought to be. Changing the laws in the area of DWI, the law of the sale of alcohol, or the operation of our correctional system. These are all areas of inquiry that you need to pursue to find out how your panel thinks. Great question. I'm afraid the one up on the upper right doesn't show up in this PowerPoint, but it's Keep Austin Weird. The bumper sticker at the bottom says, friends don't let friends drink and drive. If you ask this question directly, you're going to get a bunch of hands that go up. And you're going to find people who have bumper stickers on their cars that tell you a whole lot about people who are driving those cars. Kind of a concluding question on this elimination process. Does anyone feel they might not be well suited to hear a case involving DWI? They might not really come out and say at any of those points along the way, until now, I don't think I'd be a good juror on this case. And you might want to ask them at that point, tell me about that. Why wouldn't you be a good juror on this case? Well, my son got hit by a DWI driver last year, and he was in the hospital for a long time. There were a lot of medical bills. He's never been the same. I just don't think I can get that out of my mind. That was really hard for that juror to come out and say that. But you need to thank that juror for their honesty and for disclosing that information. You need to say, that's the only way we're going to have a fair trial, when people fully disclose. And then you need to turn to these other jurors around who are nodding their heads and saying, Ms. Johnson, Mr. Smith, can you please tell me about that? Can you elaborate on that? And you'll get some more responses. You're going to have jurors who are going to say, I need to talk about this too. It's not just her, it's me. If selected to serve on this jury, Mr. and Ms. Juror, you give up certain rights. For instance, you can't talk about the case with anyone. You can't bring notes with you in to deliberate. You can't leave the courtroom without permission. And you can't perform your own investigation. That means no Googling, no internet. You can't look into this case on your own. You have to get the evidence only from the witness stand, from the evidence that's admitted by this judge. And lastly, you can't ask on your own any questions of the witnesses or the lawyers in this case. You basically have to sit there and listen. Does anybody have a problem with that? And you might find some jurors who say, I can't do that. I need to know everything about the case, and I'm not willing to sit back and just let you spoon feed me this case. Now, here's an important area that I think a lot of people overlook. On those bios that we get, and I hope you get too, it lists whether or not the juror has had prior jury service. You need to be aware of this. People who have sat on juries before are indoctrinated, and they have experience. They're the ones who know. They're probably going to be more likely to be the foreperson of the jury. And they may have, at the end of that last trial, heard things about the case that they didn't get to hear during the trial, but after the trial was over. And now they're mad because that evidence was suppressed, it was kept out, only to be learned later, and they may feel like they made the wrong decision, and if they get on a jury next time, they're going to convict. Now, This is a broad generalization, but it's one that you have to be aware of. More importantly, if they got to be the foreperson, big red flag. Forepersons probably ought not serve more than once. You might want to ask, was there anything about that experience, that prior jury experience, that makes you uncomfortable about sitting on this jury? And you may get some honest answers that lead to a strike for cause. You might want to ask, if you or a loved one were falsely accused of a DWI, well, what would you do? What would you do? And this helps you get your jurors to identify with your defendant. For instance, your defendant's already hired a lawyer. They know that. Well, what other things are going to happen during this trial that a lawyer might advise their client to do? You might want to say, I would never testify. I would never take the breath test. I would never take a blood test. I would never cooperate. I would sit there and say nothing. And if those match the facts of your case, beautiful. Inject those into Voir Dire. We're going to talk a little bit about scaled questions. And this is something that I think is really valuable and can be done when your judge is limiting you to only a 20-minute voir dire. You can still do these scaled questions. This is valuable information because it can be used for strikes for cause. It should be used for your peremptory challenges. And this is the way it looks. You tell your jury, I'm going to ask you a bunch of questions. And I want you to rank or scale the answers to these statements that I'm going to show you on a scale of 1 to 7, with 1 being strongly agree and 7 being strongly disagree. And how would you answer the following questions or statements? Well, everybody's sitting up and they're listening and they're watching because they know something big is going to happen. And more importantly, I'm going to call on each and every one of you, and I'm going to get information from everybody in the first row and the second row. I'll probably stop at the second or maybe third row on a misdemeanor. I might go further back on a felony where my strike zone has ended. But this is going to be absolutely critical. And if you start doing this and you use it with a PowerPoint slide, very valuable information. I start out with a sentencing question. The question is, the purpose of sentencing is to punish, not to rehabilitate. Juror number 1. Sir? Juror number 1? What number would you pick? 7. Strongly disagree. Juror number 2. Juror number 3. Okay, I've gotten 1, 5, and 3. And I'm going to be scoring them. I'm going to have my second chair putting little marks down on this chart. So juror number 1 for question number 1 is going to have a 7, number 2 is going to have a 3, and I think a number 5 after that. By the time I'm done asking this panel all of these scaled questions and totaling up their scores, I'm going to have a pretty good idea of how this juror thinks. But let's say you're now at the point where you've got 2 very unfavorable jurors left, and you've got 1 peremptory strike left, and you've got to choose. And furthermore, it's a coin toss. You can use that list to decide who's slightly worse for you. Here's some other questions I use. It should be illegal to drink any amount of alcohol and drive. By the way, let me go back and give you the cite to this. It's Cardona. It's an unpublished case out of El Paso, but it's based on the idea that juror questionnaires do this routinely. In death penalty cases, you'll see it in a written questionnaire. And the courts routinely talk about this type of question as being a valid question having to do with punishment. And so once you've established for everybody, the judge, the prosecutor, and the jury is now familiar with this, that you can move on and talk about other areas of inquiry, such as alcohol. It should be illegal to drink any amount of alcohol and drive. Juror number 1, number 2, number 3, and so on. I ordinarily keep my home very organized. This idea came out of a case that I was trying involving a firefighter. My thought was that jurors are going to either hold the firefighter up to a very high standard for being a public servant or give him some credit because he's a public servant. I wanted to eliminate all of those perfectionists on that panel who would be extremely judgmental and try to hold my client up to that very high standard that he could never fill. Everything in life must be done to my level of satisfaction, which is often higher than anyone else's. It's unacceptable to make a mistake. You get the idea, and you can use the facts in your case to infuse these scaled questions with statements that are going to come up again later.
David, why did you use 1 through 7 as opposed to 1 through 10?
Great question. If you look at this scale, first of all, the psychologists tell us to do this. And it makes sense because if you do an even number, say 1 to 10, there's going to be exactly a whole number. It's going to be 5.5. If you get juror number 8 over here who says, well, I'm sort of a 5.5, You don't want to spend a lot of time saying, come on, give me the whole number. Is it a 5? Is it a 6? Where are you? We don't do math here. So an odd number is good. They say 5 is good, 7 is good. 7, I think, gives you a little bit more of a nuanced answer because it gives the jurors some flexibility to pick greater degree of answer.
And why do you have strongly agree as the lower option?
Another great question. When you put these questions together, you really have to think about what you're going to do at the end, which is total them up. If you've got an answer where the low score is your bad juror, you want to make sure all of your questions yield low scores for bad jurors. Make sure they're consistent. You can reword the question, just make sure a low score, a failing score, is a bad defense juror. High score, good juror. But we're talking about juror elimination. Let's focus on low scoring jurors. All of those answers that find unfavorable jurors should be low. And another great case, I had a case involving a person who was charged with DWI. She really needed to go to the bathroom. And that officer said no. And she was reduced to tears. She was crying, she was begging, she was pleading over and over and over. Please let me go to the bathroom. I'll do those tests. Just let me go to the bathroom. I've got to go now. And the officer repeatedly said no. Well, it was around the time of Abu Ghraib, and those photos were coming out, and people were talking about gathering information through using extraordinary means. People had no sympathy for an officer, even though he may have been right for not letting her go to a public restroom. They started holding it against the officer. Again, we're infusing the facts of our case into voir dire so they're ready to hear it when it finally comes up. I went further and talked about changing temperatures to extract information so that the jury was connecting with this idea of what was going on in the media at the time. We talked about preventing access to a lawyer. How many times have you looked at a video where the client has raised the hand? Well, the client has said, I'd like to do these tests, but I'd like to talk to my lawyer first. Anybody seen that on videos? Well, a lot of times the officers are going to say, sorry, you don't get to talk to a lawyer. Are you going to do these tests or not? A person doesn't get to talk to a lawyer until they're at a critical stage of the process, but jurors don't know that, and jurors are going to hold it against that police officer for saying, no, you don't have a right to talk to a lawyer. You're asking, are you going to hold it against this officer for not letting my client assert one of their rights? Now, I've talked a little bit about injecting your facts into your case, and everybody knows about stand defer. You're not allowed to ask commitment questions. In other words, ladies and gentlemen, if I show you this, can you promise me that you will or will not convict? You can't contract with the jury in a criminal case like that, and you can't talk about evidence that hasn't been admitted yet. It may or may not come in. But you can talk in a general way about circumstances that surround DWI, and it's not a bad idea to look at your case carefully and think about what facts do I really want these jurors to be thinking about before they get picked for a jury. Instead of intoxication, what are some other reasons an innocent person might drive faster than the speed limit? I've got a person who is stopped for speeding. I want them to start thinking about the fact that they have been speeding before, these jurors have. And they might give you answers like, well, maybe they were changing the radio station. Maybe they had an emergency. Maybe they had a distracting conversation with their passenger and just were not paying attention to their speed. They could have been talking on the cell phone. You know, in this day and age, how many drivers do you see on the road not texting, not talking on their cell phone? And they can all relate to the idea that if your client was stopped for speeding, that could have happened to them. Or just plain being in a hurry. They had to be somewhere. And I'll use graphics. I'll use pictures in my voir dire because I know that people are going to get tired of listening after a while. And if I splash a photo or a graphic up on that page for them to look at, they connect with that and they say, okay, what kinds of things do you do to keep from driving over the speed limit? It makes them reflect. It makes them think about how this, again, could have been them. And I hit them with, does speeding equal DWI? The NHTSA manual doesn't include it as a factor that the police can consider when they're doing their vehicle in motion stage in the NHTSA manual. And those officers who know that will agree with you. So why not get the jury to agree with you right now and say speeding does not equal DWI? What if they went through a red light? It's the same thing. You want to get something up there to start getting them talking about going through a red light and ask them, does going through a red light equal DWI? And you'll get some jurors who say maybe, maybe not, sure, I don't know. And get them to say, answer this one. What are some reasons a police officer might arrest a person for DWI when the person is not intoxicated? Get your defense in front of that jury early. we're not intoxicated. We were driving, we had a drink, but we don't meet the definition of intoxication. Get that jury to understand the officer could be mistaken, could have mistaken the odor of alcohol for intoxication, or you may have a clumsy client who just does poorly on agility tests. Now, I had a case involving a designated driver. She was driving her sister home from a restaurant. Her sister was extremely intoxicated. My client had nothing to drink. And I want to get to that in my voir dire. I want them to know that, so that when they hear these facts, it's not the first time, and they're looking for it. So I asked, if you drove somewhere and you had too much to drink, what are some responsible things you could do? And obviously, they're going to talk about getting a designated driver. They'll talk about getting a taxi cab or sleeping it off, which, by the way, might have been a good answer or a good voir dire question in our problem, where we have somebody who actually nods off in the right-hand lane. Fine. Now we're talking about designated drivers. Next slide. You're the designated driver, and it's late at night. Your passengers have been drinking. You're taking them home. You're stopped by the police. What are you thinking as the officer approaches your window? Obviously, they're going to start thinking, he's going to suspect me of DWI. Everybody else in my car is intoxicated. What else could he think? And now, add to that, let's say there are drugs in the car. Ask your juror. You're the designated driver. You've been stopped. Everybody else is intoxicated. What are the dangers of driving someone home who uses illegal drugs? And we've all seen the cases where it's okay. Probable cause exists to arrest the driver, even though they're not physically on the driver, but they're somewhere in the car. Let's talk a little bit about the law on DWI. I know that everybody here is a Top Gun DWI lawyer, but there are some interesting things going on with definitions, and I think presentation is important. Now, the prosecutors have covered this already, right? So does it make any sense for us to go over it again? I think it does, because the prosecutors are going to cover this in a way which is really helpful for them and really unhelpful for us. They're going to cover it in a way where the street law becomes courtroom law, where drink, drive, go to jail becomes the requirement, not a person is DWI when that person is intoxicated while operating a motor vehicle in a public place in a particular county on a particular day. Break it down for them. These are elements that have to be proven, and when you start talking about the burden of proof later on, it's important for them to have this model in their mind that they're talking about specific elements, and each one of them has to be proven beyond a reasonable doubt. So I want to talk about intoxicated and what it means, because this is probably, in a non-breath test case, the real issue in almost all of our cases. Intoxication means not having the normal use of mental or physical faculties by introduction of alcohol, drugs, or a dangerous drug into the body. And of course, intoxication has a statutory definition. Normal use does not. What does normal use mean? Well, it means whatever the jury thinks it means, right? So does normal use mean walking along normally, swinging your arms the way a normal person does, or does it mean abnormally, extraordinarily, like walking a tightrope? And your jury will say it means walking like that lady on the right, walking normally. That's what normal means. Great. You've just infused some facts into your voir dire, because now when they see those sobriety tests, they're going to say, wait a minute, that's not a normal test. That's not something a normal person does. That's something that an acrobat does. So try to use these images. Try to get them talking about what normal means. Another way of looking at normal is whether your client may have a disability or an infirmity. I actually had a client with a broken arm once, and they made him do the sobriety tests, and he was kind of off balance. He had a heavy weight on one side of him, and his arm hurt. He was also taking Vicodin, a prescription drug for the pain. And he was expected to act like everyone else, which was not fair, and the jury said so in their verdict. Now, normal use also has to do with mental faculties. So when we're asking someone to judge the normal mental faculties of our client, Mr. Mailer, should he be held to the highest of mental standards? The lowest of mental standards? Should he be normal? And what does that mean under the conditions in which he's being tested, which are late at night usually, under stressful, high anxiety conditions, with an authority figure barking orders at him, knowing that the performance and test results are going to impact the rest of his life? Well, I'd say even under normal test-taking conditions, one test is not going to affect the rest of your life. Unlike this one, it's not a normal test, it's not a normal situation for anybody, and if your client makes a mistake, that doesn't mean he's intoxicated. Normal doesn't mean perfect. They may be confused about the direction they're going, where they came from. They may not know exactly how many beers they had that night. Remind the jury, normal does not mean perfect, and the legislature was free to use that word if they wanted to define intoxication that way. They didn't. So we've got normal use, we've got a question about what it means, we know that it applies to both mental faculties and physical faculties, and ask them this. If you drink alcohol, how does the passage of time affect the normal use of your faculties? And now you're adding another factor in, the time, how much time in between the time that they actually consumed alcohol, the time that they were found driving, and now the time that they're actually doing these tests, and you're going to get some interesting responses from your jury. And so have them thinking about alcohol consumption, normal use, and the elimination and absorption of alcohol. Public place does have a definition, and there's just about no place in Texas that's not a public place anymore. A public place means any place to which the public or a substantial group of the public has access and includes, but it's not limited to, streets. You can read the rest of that. It's pretty all-inclusive. But if you're driving on a dirt road on someone's property, you're probably not on a public place. And you might want to look and see whether certain roads have been classified as public and make the argument to your jury, this is not a public place. He may have been intoxicated. We're not saying that he was, but this certainly wasn't a public place, and you can find him not guilty for that and that alone. Operate. Term is defined by case law. The leading case on this is Denton v. State, and here they gave us a definition that to operate a motor vehicle means to take action that affects the functioning of the vehicle in a manner that would enable the vehicle's use. It is the exertion of personal effort to control the vehicle to affect its functioning. So sitting in a car, engine off, probably not operating unless you drove there in the first place, and a reasonable inference can be made that that's the only way you could have gotten there. Well, what about if you're asleep in a car and the car is running? Is that operating? Well, you're not really exerting any personal effort to control the vehicle, and the officer didn't see you turn on the vehicle, so he can't testify that you exerted any personal effort to control it. Austin, in the Third Court of Appeals right now, there's a decision that was decided in November. It's called ALOCCA. It's not in the paper, but it's ALLOCCA. It was an ALR decision. It was brought up. In that case, the driver was sleeping in the car, seat was reclined, engine was running, heater on. Court found that was not operating a motor vehicle. So match up your facts with those cases and argue to the judge pre-trial and then again to the jury at trial, this wasn't operating. It's not operating a motor vehicle. I want to move on slightly to our strikes for cause. We're not there yet, but I wanted to give a practice tip. You have to ask the question the right way. You may want to go to your statutes and your pattern jury charges and sample that text and put that up on a screen. So there's no one who's going to question your usage of the language. In any breath test refusal case, you know that prosecutor is going to get up there and say, ladies and gentlemen, he refused the breath test. And in Texas, refusing to take the breath test is evidence of guilt. Now, the jury may buy that. What I don't see a lot of criminal defense lawyers doing is quoting this language, which says, a specimen of a person's breath or blood may not be taken if a person knowingly and voluntarily refuses to submit to the taking of a specimen designated by a peace officer. Now, there are some recent exceptions to that, but in general, that's the law. The exceptions you can talk about later. Why not get up there and tell that jury, hey, refusing the breath test might be evidence of guilt. It may not be evidence of guilt. You have a right to refuse to take the breath test. Remind the jury of that, and don't let them get sucked in to an argument you haven't rebutted, even at the earliest of stages in voir dire. Field sobriety tests. Ask that panel, what have you heard about field sobriety tests? Would you take them? Would you not take them? What are some reasons that an innocent person would refuse to take the field sobriety test? And you'll hear it. I'm uncoordinated. I don't want to give the police an opportunity to convict me. I've heard never to take the test from lawyers. Ask them, if someone refused the field sobriety test, could you be fair and impartial? This is a question that I think a lot of prosecutors are asking in total refusal cases, and I think you should look at it, study it, and figure out a response or preempt it in your voir dires. And they're going to ask people, how many people have stood next to someone at a social occasion and sensed that the person was intoxicated? How did you know? And the prosecutors, are going to get that panel talking about how we don't really need field sobriety tests. We don't need to be sure. We don't need, anybody can tell when somebody else is intoxicated. Well, maybe we want to address that in our voir dire and say, no, that's really not the case. And we actually have standardized tests so that we can make accurate, valid determinations about whether somebody truly is or is not intoxicated. There's a reason we have those tests. Maybe you want to use them for the defense as opposed to fighting against them. Great questions, which I've used in voir dire and cross-examination, consist of this. If you were to design a test to make a person lose their balance and fail, would you make that person stand with their feet together or their feet apart? And everybody will say, well, if I wanted to make them fail, I'd make them stand like this. Will you have them walk heel to toe or walk normally? If I wanted them to fail, I'd make them do the real difficult part of walking heel to toe. If you wanted them to lose their balance and fail, would you have them touch their hands to their sides while they're walking, or let their arms move naturally? And they'll say, I'm going to make it really tough. I'm going to make them walk with their hands at their sides. What about standing? If you wanted them to fail, would you have them stand with one foot in the air, trying to balance, or would you have them stand normally on 2 feet? And obviously what you're doing is you're trying to get that jury to think about these tests as tests that were designed to make people fail. The more you can get that jury convinced that that's what these tests do, and that's what this officer is trying to do, the closer you are to a not guilty verdict. And these officers didn't design the test, but that doesn't matter. Ask them this. If you were on a jury and one jury said somewhere before the end of the case, I've heard enough, let's just convict him, ask that juror, how would you feel if you heard that? And what would you say to your fellow juror? Because now you're making it okay for the panel to go talk to their fellow jurors about behaving properly, not talking about the case until they have all the evidence, close of evidence, jury's charge. You might want to remind them on the right to remain silent that the fact that the defendant does not testify shall not be considered a circumstance against her. Read this straight from the charge. You will therefore not consider the fact that the defendant did not testify as a circumstance against her. You will not allude to, comment on, or in any manner refer to the fact that the defendant has not testified, and call on your jurors again. Mr. Smith, I believe that you can be fair in just about any kind of criminal case where the defendant testifies, but I think you might have some trouble where you don't get to hear from the defendant himself. Am I correct about that? Strike for cause. Ask them who wants to hear from the defendant. You'll get some hands up. See if you can work that into a strike for cause, because they can't be fair. They can't not comment on the defendant's silence. Reasons a person may not want to testify include they just don't come across well. They're afraid of being tricked, or the lawyer tells them not to testify. I'm going to leave you with one last thought before we close, and this is one that comes up a lot, I think. You're going to have jurors who say, I can't do this. I run a business. I live paycheck to paycheck. I can't really sit on a 2-day, 3-day, 4-day jury trial. And the law is pretty clear on that. That's not a reason to excuse somebody. Economic hardship will not fly. However, if they're preoccupied with business, work, school, or personal problems, they will have problems listening to the evidence. Get them to admit they will have trouble remembering the testimony. Ask them if they're biased or prejudiced against the defendant. This can be based on race, religion, gender, national origin, and you may get some folks who own up to that and say, I just can't be fair. Ask them if they don't like the definitions of DWIs, that the state has the burden of proof, that the state has to prove that case beyond a reasonable doubt, that your defendant is presumed innocent, and that he has a right not to testify. Ask them about their experiences. I wish you all the best. Good luck on picking juries and eliminating them.